This is an application for leave to appeal against a judgment of the Supreme Court of Appeal handed down on 6 February 2024. This application is yet another instance of the unending litigation between Vodacom Pty Ltd, the applicant, and Mr. Nkosana Makate, the respondent, a former employee of Vodacom. The litigation, which spans just under 2 decades, concerns compensation owed by Vodacom to Mr. Makate for the Please Call Me PCM idea. The first round of litigation culminated in a judgment in which this court in 2016 declared that Vodacom was bound by an agreement concluded by Mr. Makate and Mr. Philip Geisler, the then Director of Product Development and Management at Vodacom, in respect of the PCM idea B, ordered that Vodacom and Mr. Makate should negotiate in good faith to determine reasonable compensation payable to Mr. Makate in terms of the agreement. And C, directed that in the event of disagreement on reasonable compensation, Vodacom's Chief Executive Officer, the second respondent, would break the deadlock and determine such compensation. The second and current round of litigation commenced as follows. Negotiations between Mr. Makate and Vodacom were unsuccessful, and the matter was referred to the CEO after a thorough going process. No, I think my law clerks gave me a wrong hand-down note. Apologies for that. The second and current round of litigation commenced as follows. Negotiations between Mr. Makate and Vodacom were unsuccessful, and the matter was referred to the CEO. After a thoroughgoing process, the CEO determined that 47 million rand was reasonable compensation for Mr. Makate. Dissatisfied, Mr. Makate took the CEO's determination on review to the High Court of South Africa, Gauteng Division, Pretoria. The High Court found in Mr. Makate's favor and ordered a remittal of the determination to the CEO subject to certain parameters. Vodacom appealed to the Supreme Court of Appeal, which dismissed the appeal. The Supreme Court of Appeal also substituted the High Court order with its own. A part of the Supreme Court of Appeal order that is worth highlighting is a portion that read as follows. I'm paraphrasing. Mr. Makate was entitled to 5% to 7.5% of the total revenue share of the PCM product, together with moral interest thereon. Alternatively, interest in terms of the prescribed rate of interest at 55 of 1975, and that the total revenue of the PCM product should be calculated according to the computation models for compensation proposed by Mr. Makate. Vodacom has now appealed to this court. Its main argument against the Supreme Court of Appeal's judgment is twofold. First, the Supreme Court of Appeal acted beyond its jurisdiction by substituting the High Court order with an order of its own in circumstances where Mr. Makate had not cross-appealed against the order of the High Court. The Supreme Court of Appeal thus determined an issue that was not before it in breach of the rule of law and the right to a fair hearing protected in Section 34 of the Constitution. Second, continues the argument, there were several seriously disputed issues in respect of which swaths of evidence were adduced and written and oral argument presented by both parties, all of which were disregarded or misunderstood by the Supreme Court of Appeal. This, according to Vodacom, amounted to disregarding the true issues that had to be decided by the Supreme Court of Appeal. Vodacom concludes this second argument by submitting that the Supreme Court of Appeal's disregard of the real issues on appeal constitutes a total failure of justice in breach of the rule of law and violates Vodacom's constitutional right to a fair hearing. Mr. Makate counters that Vodacom's application does not engage this court's constitutional or general jurisdiction and that, therefore, we must not entertain it. Mr. Makate argues that the Supreme Court of Appeal did not exceed its jurisdiction as the substitution issue was pleaded before the High Court and as it was relevant to the proceedings before the Supreme Court of Appeal. As a result, the appropriateness of that substitution was fully ventilated by the parties before the Supreme Court of Appeal. Mr. Makate further argues that the Supreme Court of Appeal did not disregard or misconstrue the evidence or issues that it had to decide. The judgment of this court penned by me is unanimous. It is concurred in by Maya C.J., Majid J., Matopo J., Shantla J., Rogers J., Sigobin A.J., Theron J., and Chikri J. This court has agonized over Vodacom's submission about a court's disregard of facts giving rise to a total failure of justice. How flawed must an assessment be for it to cross the line to constitute a failure of justice and thus a violation of the rule of law and the right to a fair hearing guaranteed in Section 34 of the Constitution. Put differently, what is the threshold above which our constitutional jurisdiction is engaged? In what circumstances does the assessment fall short of that threshold so as to be hit by the Busak or Mbata principle to the effect that dissatisfaction with a court's assessment of facts does not engage our jurisdiction? On the face of it, Vodacom's argument seems to take us to a slippery slope that will result in the reach of the Busak and Mbata principle being difficult, if not impossible, to implement. Will that principle not be unacceptably attenuated? Whatever the attendant difficulties, is the real question not whether there has been a total failure of justice? In this context, I am not concerned with esoteric debates about what justice is. I am concerned with justice in the sense of a reasonable expectation that within the bounds of human fallibility, courts will do what is expected of them. Justice and indeed the court process are not about perfection. Courts are not to be held to some abstract standard of perfection. It is unsurprising that in the case of Bennett, this court held that judicial officers are not superhuman beings who do not make mistakes. This is why there is an appellate process to correct mistaken findings on law or facts. But there are errors in the assessment process that are so fundamental as to go beyond this ordinary level of human fallibility. And those are errors that are so far-reaching as to result in a total failure of justice, in the sense that a court ends up failing fundamentally to decide the case before it. It fails totally to consider the case before it. This I call the duty of proper consideration. This duty is closely related to the duty to give reasons. That is so because it is in the reasons or lack thereof that we can assess that there has been a failure to discharge the duty of proper consideration. It should matter not that this failure may manifest itself through an improper factual assessment. What is important is that the flaws in the assessment must be so fundamental and pervasive as to vitiate the court's judgment. Once vitiated by flaws of this nature, a court's decision is a non-decision. Without a decision, a court will have failed in its very raison d'etre. Is there support for this proposition? Definitely not in South Africa. This is new ground within South Africa's jurisprudence. What about elsewhere then? Authority that is on point is to be found from the jurisprudence of the European Court of Human Rights, the ECHR. On point because the jurisprudence also deals with the right to a fair hearing contained in Article 6.1 of the European Convention on Human Rights, which protects the right to a fair hearing. In Zaidov versus Azerbaijan, the ECHR held that the convention is intended to guarantee not rights that are theoretical or illusory, but rights that are practical and effective. The right to a fair trial cannot be seen as effective unless the requests and observations of the parties are truly heard. That is to say, properly examined by the tribunal, close quote. I accept this holding. This holding ties in with Vodacom's complaint that the Supreme Court of Appeal did not truly hear or properly examine the facts and issues before it. The question that remains is whether there is substance in Vodacom's claim. But before going there, let me caution that unsatisfactory or even incorrect reasoning and defects in a judgment do not necessarily equate to a failure by a court to discharge its duty of proper consideration. The duty of proper consideration is about the substance of a judgment viewed holistically. Flaws in the assessment during the adjudicative process that are so fundamental and pervasive as to vitiate the court's judgment constitute a failure of justice and thus a breach of the rule of law and the fair hearing right guaranteed in Section 34 of the Constitution. Let litigants be warned that this conclusion is not an open sesame for them nitpickingly to take every and any point on the court's assessment of facts and issues. Back to the question that remains. Did the Supreme Court of Appeal's assessment of the facts and issues constitute a failure of justice? At times, the Supreme Court of Appeal judgment is characterized by confusing reasoning. At other times, it is characterized by statements that evince a disregard for or lack of awareness of the facts and issues. There are several examples illustrating that the Supreme Court of Appeal breached its duty of proper consideration. They are dealt with fully in the judgment, an exercise which cannot be done in this summary. I will illustrate with a few. A ready example is the question whether the 47 million rand awarded by the CEO was inequitable, was central to the Supreme Court of Appeal's determination against Vodacom. This question concerned whether the award of 47 million rand was manifestly unjust or patently inequitable. If the Supreme Court of Appeal found that the CEO's determination was inequitable, then Vodacom's appeal had to fail. This is how material this issue was to the Supreme Court of Appeal's determination. Despite the centrality of this issue, the Supreme Court of Appeal merely highlighted the parties' arguments in respect of this issue and did not engage with or pronounce upon those arguments in any meaningful way. Further, the Supreme Court of Appeal failed to decide the question whether Vodacom's determination was in fact inequitable. A shortcoming of this nature on such a crucial issue constitutes a breach of the duty of proper consideration. Moving on, in his determination, the CEO extensively dealt with evidence on PCM revenue in the context of Vodacom's voice revenue. As part of this, he referred to calculations of voice revenue in one of Mr. Makate's models and said those calculations or estimates need to be carefully examined. And indeed, he examined them carefully. Despite all this detail in the CEO's assessment, the Supreme Court of Appeal held that the CEO's conclusion was reached, open quote, without saying why, close quote. This is evidence that the Supreme Court of Appeal should have been aware of and assessed. Another example that I must touch on is the apparent readiness of the Supreme Court of Appeal to accept whatever Mr. Makate said with regard to the calculations. This is evidenced by the manner in which that court adopted Mr. Makate's computation models for compensation. The Supreme Court of Appeal said that, open quote, absent any evidence that Mr. Makate's computation is wrong, I can find no reason why Mr. Makate's computation should not be accepted as correct. This is surprising given that Vodacom submits that the entire debate in the Supreme Court of Appeal turned on the question whether the models presented by Mr. Makate or those of the CEO should be preferred. And unsurprisingly, because that is what the case and indeed the appeal were about, everything about Vodacom's case was about demonstrating that Mr. Makate's computation was wrong. So there was evidence that sought to demonstrate that Mr. Makate's computation was wrong. Whether or not Vodacom succeeded in this regard is something else and on which we do not have to make a pronouncement. The point is that the Supreme Court of Appeal did not consider this evidence at all. Here is the final example. The Supreme Court of Appeal also appears not to have considered the substantive content of the substituted order it granted in favor of Mr. Makate. The Supreme Court of Appeal simply copied paragraph 2 of Mr. Makate's High Court notice of motion verbatim, thus incorporating the revenue sharing range of 5% to 7.5% and two alternative rates of interest, mora interest or interest in terms of Section 2A5 of the Prescribed Rate of Interest Act. The alternatives in the order translate to huge differences in the amounts payable across the revenue sharing range and between the interest calculated on the alternative bases. If the Supreme Court of Appeal had properly considered the relief, it would have realized that although a litigant can claim relief across a range or in the alternative, a court has to fix the relief with precision. The purpose of giving these few examples is to illustrate that the Supreme Court of Appeal, A, failed to provide adequate reasons for its judgment, B, disregarded or was unaware of certain material facts and issues before it, C, at times merely highlighted the parties' arguments in respect of central issues but did not engage with those arguments in any meaningful way, D, failed to assess evidence that was adduced by the evidence which it ought to have assessed, and E, readily accepted whatever Mr. Makate proffered without explaining why it did so. Based on these holdings, I conclude that the Supreme Court of Appeal failed to discharge the duty of proper consideration. This failure violates the rule of law and the fair hearing right protected in Section 4 of the Constitution. Must we deal with the ground of appeal on the lack of a cross appeal? Ordinarily, we would not have to. That is so because what I've just held on the failure of Justice Point is dispositive of the appeal. But I feel that this court must have the last word on this ground. That is so because the manner in which the Supreme Court of Appeal dealt with the issue underlying this ground, i.e. upsetting the order being appealed on an issue in respect of which there was no cross appeal, will be considered binding by courts that are bound by judgments of the Supreme Court of Appeal. My conclusion on this ground is that, absent a cross appeal by Mr. Makate against the order of the High Court, the Supreme Court of Appeal lacked jurisdiction to substitute its own order for that of the High Court. Vodacom raised other grounds of appeal. Having disposed of the two issues that I've just discussed above, it is not necessary for us to address the other grounds of appeal. What must become of the appeal? This judgment merely highlights the fatal shortcomings in the Supreme Court of Appeal's judgment. It does not make its own decision on any of the attendant issues. Those are the very issues that ought to have been decided by the Supreme Court of Appeal. It seems to me that just and equitable remedy is for the appeal to be decided on its merits by the court that ought to have decided it. More importantly, in the main, what remain for determination in the appeal are factual questions that do not ordinarily fall for determination by this court. The jurisdiction of the court is confined to constitutional issues and arguable points of law of general public importance, which ought to be considered by it. In this judgment, we dealt with factual issues, but crucially, without deciding them, purely to demonstrate the Supreme Court of Appeal's failure to comply with the duty of proper consideration. We cannot suddenly be at large, as the legal language says, to determine those factual issues. The matter must be remitted to the Supreme Court of Appeal for a proper determination of the appeal, and that must be before a differently constituted panel of the Supreme Court of Appeal. The court makes the following order. 1, leave to appeal is granted. 2, the appeal is upheld. 3, the order of the Supreme Court of Appeal is set aside. 4, the matter is remitted to the Supreme Court of Appeal to be reheard by a differently constituted panel of judges of that court. 5, each party must pay their own wasted costs in respect of the abortive hearing of the matter in the Supreme Court of Appeal. 6, the first respondent must pay the applicant's costs in this court, including the costs of 3 counsel. I hand down the judgment.